up to a year on the criminal damage. As to the DUI, before you can place on probation,
it's been dark way too long in this place. That bright smile long gone been replaced. From ear to ear, I see that fear in your face. Tell me when the last time you felt safe, cause there's some evil people in the streets. Evil at your front door, even while you sleep. It's time to raise up, show that evil we ain't weak. We don't turn the other cheek. I can show you how to be strong. Come on, follow me. Heard you looking for a hero. Well, look up. No more running from the bad guy. I'ma stare him in the eye like, what's up? I know the journey got hard for a minute, but I ain't giving this up. Yeah, I got the heart of a champion. If I get knocked down, I get back up. We go through bad days, hard times, low pay, high crime, pathways to a life without sunshine. I'm the lifeline. With this life, I'm gonna be the pipeline, shining in the nighttime. Bet on me to swoop down. I'ma go toe to toe. Already know that I'm never gonna back down. Bet on me to stand tall. I take on anything for my crew. Bet I risk it all. Wicked people in the streets. Corruption in the politics and the police. It's time to raise up. Take a stand against the seat. We won't take a back seat. I can show you how to be strong. Come on, follow me. Heard you looking for a hero. Well, look up. No more running from the bad guy. I'ma stare him in the eye like, what's up? I know the journey got hard for a minute, but I ain't giving this up. Yeah, I got the heart of a champion. If I get knocked down, I get back up.
Plea of guilty. You can't change your mind and ask for withdrawal from the plea agreement unless you can show a manifest injustice to it.
Get back up.
When you plead guilty, you go back to constitutional rights.
If I get knocked down, I'ma get back up. If I get knocked down, I'ma get back up. If I get knocked down, I'ma get back up. I'ma get back up. I'ma get back up. I'ma.
You get the right to this.
Heard you looking for a hero. Well, look up. Yeah, no more running from that bad guy. Don't worry about it. I'm right here. What's up? I know that journey been hard for you. Okay, I ain't giving up. We ain't giving up. I got the heart of a champion. If I get knocked down, I get back up.
Yes, Judge.
You do have the right to file a petition for post-conviction relief within 90 days of sentencing. So I'm going to ask for your plea. As to amendment count 1, criminal damage, a Class 6 undesignated offense that occurred on or about August 22nd, 2024 in violation of 13-1602A1 and B4, how do you plead, guilty or not guilty?
Guilty.
As to count 2, driving while under the influence of liquor, drugs, vapor releasing substances, or any combination, a Class 1 misdemeanor that occurred on about August 22nd, 2024 in violation of 28-1381A1, how do you plead, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and on your own?
Yes, sir.
All right. Counsel, going to give me a factual basis.
Your Honor. So on the 22nd, as to amendment count 1, Judge, on or about the 22nd of August 2024 within Pima County, Mr. Yuan did recklessly damage Tucson Fire Department's exterior of their fire station, causing damage that was greater than $1,000 but less than $2,000 in violation of statute. On that same day within Pima County, Mr. Yuan drove a vehicle while he was under the influence of intoxicating liquor, and he was impaired by that liquor to the slightest degree.
All right, Mr. Doan, do you admit that's what you did?
Yes, sir.
Is the state satisfied with the factual basis?
Yes, Judge.
Court finds there's a factual basis for the defendant's plea. Incorporate the grand jury transcript to find the defendant's plea is made knowingly, intelligently, and voluntarily. Court accepts Mr. Doan's plea at this time. I'll affirm current release conditions, order a pre-sentence report, order the defendant to comply with the interview process, and we'll set this for sentencing.
Two things, Judge. First, the grand jury transcript was actually omitted from the plea as part.
All right, I'll strike that. It's not part of the factual basis.
Thank you, Your Honor. And then, as for sentencing, we could do just slightly over 30 days. We'd be willing to waive time. I come back on the. Are you dark on Tuesdays?
Wednesday.
Wednesday? Would you be able to do Tuesday the 17th? You need Fridays, right? Yeah. Could we do Friday the 20th?
Yes. So we'll set sentencing for Friday the 20th, and he'll need to have completed that drug screening education or treatment program, obviously before sentencing.
We'll have that receipt for
So
you.
yeah, have that done so I can get credit for that. Okay, Mr. Stone, we'll see you back on Friday the 20th for sentencing, okay?
And
All right.
Judge, Mr. Dewan has travel plans on June 27th through July 13th. Would you like a written motion to allow
You said the 27th through what?
July 13th? It would be after sentencing, so.
Why don't you address it then?
Okay, sounds good.
Okay, all right. With that, we're adjourned and you're excused.
David Hammond, page 1.
State of Arizona versus David Lee Heyman, CR 2024-1574. Pretrial O'Donnell and a change of plea. Parties' appearances. We'll start with the state.
Peter Abdus appearing for CES, CPB2, James Dobby for the state.
Good morning, Your Honor. Call now for Mr. Hammond. He's present for speakers.
Okay, do we have a plea in your case?
We do have them.
Yeah. As to our 10:30 matter, I want to finish everything. I have to take a break before we bring him up, okay? All right. Mr. Heyman, I'm going to go over this plea agreement with you. I know you've been sitting here and heard a lot of plea agreements this morning, so you probably heard all this, but I have to ask you each question individually. Please state your full name, your date of birth. What's the highest grade you finished in school? Okay. Do you read and understand English? Are you under the influence of any drugs, alcohol, or medication? Your lawyer has handed up this written plea agreement. Have you had the opportunity to go over the written plea agreement with your lawyer? Has your lawyer answered all your questions? Are there any questions about the plea agreement your lawyer has not answered? All right. If I go to page 4 of the plea agreement, there's a signature line for David Lee Hammond. Is that your signature above that name? Did you understand the plea agreement at the time you signed it? Has anyone promised you anything not contained in the plea agreement? Has anyone forced you or threatened you in any way to get your inner plea of guilty? I'm going with a possible sentence I can impose based on your plea of guilty. You're going to plead guilty to one count. Amend count 1, solicitation to possess a deadly weapon by a prohibited possessor, a Class 6 designated felony that occurred on about April 12th, 2024. Probation is available. I could place you on probation for up to 3 years. As a condition of probation, I could order you held in Pima County Jail for up to 12 months. Alternatively, I could sentence you to prison. The presumptive sentence will be a year, maximum 1.5 years, aggravated 2, minimum half year, mitigated third of a year. If sentenced to prison, you'd have to complete at least 85% before you'd be eligible for release, and upon release, you'd be subject to community supervision. Also, if I place you on probation and you violate that probation, I could continue on probation, including a jail sentence, or revoke your probation and sentence you to prison for the length of time I just went over. Do you understand it's a possible sentence I can impose based on your plea of guilty? You'd also have to forfeit the weapon. Are you currently on probation or parole in any jurisdiction for a felony or misdemeanor? The court does not inquire into your citizenship status, but if you're not a U.S. citizen, pleading guilty could cause you to be deported or removed or prevent you from gaining legal status or U.S. citizenship. If you're convicted of a felony, certain civil rights will be suspended. These include the right to vote, serve as a juror, hold public office, and possess a firearm. There may be other collateral consequences. Do you understand, Mr. Heyman, that once I accept your plea of guilty, you can't change your mind and ask to withdraw from the plea agreement unless you can show a manifest injustice? Do you understand that? When you plead guilty, you give up certain constitutional rights, among those the right to trial by jury, that his verdict be unanimous and beyond a reasonable doubt. You give up the right to confront and cross-examine witnesses who testify against you, and the right to subpoena witnesses to appear on your own behalf. You give up the right to present other evidence, testify at the same time. If you chose not to testify, that could not be used against you. You give up the presumption you're innocent until proven guilty beyond a reasonable doubt. You give up the right to have the jury determine aggravating factors unanimously and beyond a reasonable doubt before I can give you an aggravated prison sentence, and you give it the right. Do you understand all those rights you're waiving by pleading guilty? You have a right to file a petition for post-conviction relief within 90 days of sentencing. So I'm going to ask for your plea. As to amend count 1, solicitation to possess a deadly weapon by a prohibited possessor, a Class 6 designated felony that occurred on about April 12th, 2024 in violation of 13-1002 and 13-3102A4. How do you plead, guilty or not guilty? Are you pleading guilty voluntarily and on your own? All right, Mr. Knauer, can you give me a factual basis?
Yes, Your Honor. On or about April 12th, 2024, here in King County, Mr. Heyman knowingly requested to possess a firearm.
Okay, Mr. Heyman, do you admit that's what you did? All right. The court finds that there's a factual what? Any objection to that?
Yes, Judge, that's adequate.
Okay. Court finds there's a factual basis for the defendant's plea. Incorporate the grand jury transcript and find the defendant's plea is made knowingly, intelligently, and voluntarily. The court accepts Mr. Heyman's plea. I'll affirm with the interview process, and we'll set this for sentencing. About Tuesday, June 17th.
Your Honor, is the court available Friday the 13th?
No, I'm going to be out the 11th through the 13th on a personal matter. So I could do it on, let's see how much Paul is. You want to do it on the 10th? Tuesday the 10th? Or is that too fast?
That would be great for us.
Okay. It's a little fast, but hopefully probation can accommodate that. We'll set sentencing for June 10th at 9 a.m. I'm sorry. June 10th, 9 a.m. So, Mr. Heyman, we'll see you back in court on that day, okay? All right, with that, we're adjourned and you're excused. Wow. All right. State of Arizona versus Francisco Enrique Lopez Montoya, CR 20250781. Pretrial conference, Donald and a change of plea. Parties' appearances will start with the state.
Mike Lester, appearing for the Attorney General's office. Good morning, Your Honor.
Good morning.
Good morning, Your Honor. Curtis Fisher on behalf of Mr. Lopez Montoya, who is seated to my left out of custody.
All right. And he's being assisted by a court interpreter, correct?
Correct, Your
And
Honor.
do you stipulate to her qualifications?
Yes, I do, Your
All right. Mr. Montoya, I'm going to go over this written plea agreement with you, okay?
Yeah.
Please state your full name.
Francisco Enrique Lopez Montoya.
Francisco Enrique Lopez Montoya,
Your date of birth.
July 15, 1991.
What's the highest grade you finished in school?
High school.
Do you read and understand English?
No.
And today you're being assisted by a Spanish-speaking court interpreter, is that correct?
Yes.
And is Spanish your native language?
That is correct.
Are you able to understand what's going on in court today with the assistance of your Spanish-speaking interpreter?
Yes, of course.
All right. Are you under the influence of any drugs, alcohol, or medication?
No.
The court does not inquire, your lawyer's handed up this written plea agreement. Have you had a chance to go over this written plea agreement with your lawyer?
That is correct.
Has your lawyer answered all your questions about the plea agreement?
Yes.
Are they questions your lawyer has not answered?
No.
And was the plea agreement explained to you in Spanish?
Yes.
If I go to page 6 of the plea agreement, there's a signature line for Francisco Enrique Lopez Montoya. Is that your signature above that name?
Yes.
Did you understand the plea agreement at the time you signed it?
Yes.
Has anyone promised you anything not contained in the plea agreement?
No.
Has anyone forced you or threatened you in any way to get your own plea of guilty?
No.
I'm going to a possible sentence I can impose based on your plea of guilty. You're going to plead guilty to 2 counts. Count 2, fraudulent schemes and artifices, a Class 2 felony that occurred on about January 18th, 2024 through July 20th, 24. And then Count 3, organized retail theft, a Class 4 felony that occurred on about January 18th, 2024. Probation is available as to each count. As to count 4, I could place you on probation.
And Judge, I'd just like to step in here. In the terms of the plea, probation is stipulated between the parties as to both count 2 and count 3.
Okay. What does that mean?
So, Judge, that means that the state agrees that probation is appropriate, Judge, and we're saying it's a condition of the plea agreement that subject to the court's approval, probation will be given on these counts.
Okay, with a jail sentence, correct?
Correct, Judge. As a condition of probation, the court of plea, the defendant has to serve 180 days in the county.
Okay, so as to count 2, I could place you on probation for up to 7 years. As to count 3, I could sentence you to probation for up to 4 years. And the parties have agreed that they will not seek a prison sentence, but as a condition of the plea, that you be sentenced to 180 days in Pima County Jail. Is that, Mr. Lester, per count consecutive or concurrent?
That's concurrent between the 2 counts, Judge. I would imagine that he'd be placed on probation as to both counts concurrently.
Okay.
And then that 180 days would be the condition of basically getting off probation.
Okay. If I place you on probation and you violate that probation, you'd be subject to revocation and a prison term. As to count 2, the presumptive sentence will be 5 years, minimum 4, mitigated 3, maximum 10, aggravated 12.5, and then as to count 3, presumptive 2.5, minimum 1.5, mitigated 1, maximum 3, aggravated 3.75. Do you understand that's a possible sentence I can impose based on your plea of guilty?
Yes.
All right. Are you currently on probation or parole in any jurisdiction for a felony or misdemeanor?
No.
The court does not inquire into your citizenship status, but if you're not a U.S. citizen, pleading guilty could cause you to be deported or removed, or could prevent you from gaining legal status or U.S. citizenship. If you're convicted of a felony, certain civil rights will be suspended. These include the right to vote, serve as a juror, hold public office, and possess a firearm. The plea may have other collateral consequences. So I'm going to ask for your plea as to each. Hold on just a minute.
And there's one more thing. As part of the plea, the defendant agrees to pay restitution.
Okay.
Actually stipulated.
All right. Did I ask him the question about manifest injustice? Have I asked that yet? Okay, I'm sorry, I skipped over that. Mr. Montoya, do you understand that once I accept your plea of guilty, you can't change your mind and ask to withdraw from the plea agreement unless you can show a manifest injustice? Do you understand that?
Yes.
When you plead guilty, you give up certain constitutional rights. Among those, the right to trial by jury, that is, verdict be unanimous and beyond a reasonable doubt. You give up the right to confront and cross-examine witnesses who testify against you, and the right to subpoena witnesses to appear on your own behalf. You give up the right to present other evidence or testify. At the same time, if you chose not to testify, that could not be you. Too fast?
Yes.
All right.
If you don't mind, since it's
Okay. When you plead guilty, you give up certain constitutional rights. Among those are the right to trial by jury, that its verdict be unanimous and beyond a reasonable doubt. You give up the right to confront and cross-examine witnesses who testify against you, and the right to subpoena witnesses to appear on your own behalf. You give up the right to present other evidence or testify. At the same time, if you chose not to testify, that could not be used against you. You give up the presumption that you're innocent until proven guilty beyond a reasonable doubt. You give up the right to have the jury determine aggravating factors unanimously and beyond a reasonable doubt before I can give you an aggravated prison sentence. And you give the right to file an appeal. Do you understand all those rights that you're waiving by pleading guilty?
Yes.
Okay. Then, Mr. Lester, there's one thing you wanted to say about sentencing. I don't think I... Was it restitution?
Restitution, Judge.
Okay. And is that a stipulated amount?
It is, Judge.
Um,
That'll be found on page 2, section 2, subsection T.
all right. And Mr. Montoya, you'd also have to agree to pay restitution to Home Depot in the amount of $12,996. Do you understand that?
Yes.
You do have the right to file a petition for post-conviction relief within 90 days of sentencing. So I'm going to ask for your plea. As to count 2, fraudulent schemes and artifices, a Class 2 felony that occurred on about January 18th through July 20th, 2024 in violation of 13-2310A. How do you plead, guilty or not guilty?
Guilty.
As to count 3, organized retail theft, a Class 4 felony committed on about January 18th, 2024 in violation of 13-1819A2. How do you plead, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and on your own?
Yes.
All right. Counsel, want to give me a factual basis?
Yes, Your Honor. As to count 3, Mr. Lopez Montoya violated ARS 13-1819A2 when he took ceiling fans from Home Depot without paying the purchase price with the intent to resell them online. As to count 2, Mr. Lopez Montoya violated ARS 13-2310A when from a period beginning on January 18, 2024, ending in July 20, 2024, he obtained benefits from Home Depot via fraud. This fraud involved scanning for certain items and removing other items that were not scanned on, therefore defrauding and then obtaining a benefit from Home Depot.
All right. Mr. Montoya, do you admit that's what you did?
And if I could just supplement this a little bit.
Sure.
I'd also state as to count 3 that Mr. Montoya used an artifice, essentially replaced barcodes on certain items as to avoid.
Okay. Mr. Montoya, do you admit that's what you did?
Yes.
All right. And Mr.
Oh, sorry, Your Honor. This all occurred in Pima County. That's
Okay.
the situation.
And Mr. Montoya, do you admit that happened here in Pima County?
Yes.
All right. Mr. Lester, are you satisfied with the factual basis?
Yes, Judge.
Is there agreement that the grand jury transcript is not incorporated or not?
There is not, Judge.
Okay. So the court finds that there's a factual basis for the defendant's plea, incorporate the grand jury transcript, and find the defendant's plea is made knowingly, intelligently, and voluntarily. The court accepts Mr. Montoya's plea. I'll affirm current release conditions, order a pre-sentence report, order the defendant to comply with the interview process, and we'll set this for sentencing. And I'm looking at Thursday, June 19th, if that works for your schedule.
June 19th.
Okay, so sentencing is set for June 19th.
If I could just have one moment, Judge.
Sure.
I end up traveling around the state quite a bit, so I gotta make sure I'm not. It looks good, Judge.
Okay, so June 19th at 9 a.m. Make sure you get interviewed by probation and keep in contact with your lawyer. We'll see you back in court on that day for sentencing.
Thank you.
Okay. Sorry I read too fast.
Thank you.
All right. And this is a non-probation available, so we need some. Okay, all right, got back. All right. All right, let's go on the record in the matter of State of Arizona versus Emiliano Z. Thomas, CR 2025-0261, pretrial Donald, and a change of plea. Parties' appearances. We'll start with the state.
Peter Raptis appearing for John Strader for the state.
And Kate James on behalf of Mr. Thomas, he's present out of custody.
All right. Mr. Thomas, your lawyer's handed up this written plea agreement. I'm going to go over that with you. I know you've been in court and watched a lot of these, so I'll ask you the same questions, okay? Please state your full name,
Emiliano Z. Thomas,
your date of birth.
9/8 of 2007,
What's the highest grade you finished in school?
10th grade.
Okay. Do you read and understand English?
Yes, Your Honor.
Are you under the influence of any drugs, alcohol, or medication?
No, Your Honor.
Your lawyer has handed up this written plea agreement. Have you had a chance to go over the written plea agreement with your lawyer?
Yes, Your Honor.
Has your lawyer answered all your questions?
Yes, Your Honor.
Are there questions about the plea agreement your lawyer has not answered?
No, Your Honor.
If I go to page 5 of the plea agreement, there's a signature line for Emiliano Z. Thomas. Is that your signature above that name?
Yes, Your Honor.
Did you understand the plea agreement at the time you signed it?
Yes.
Has anyone promised you anything not contained in the plea agreement?
No, Your Honor.
Has anyone forced you or threatened you in any way to get your inner plea of guilty?
No, Your Honor.
I'm going with the possible sentence I can impose based on your plea of guilty. You're going to plead guilty to 2 counts. Count 4, drive-by shooting, a Class 2 felony that occurred on about November 17th, 2024. And count 6, aggravated assault with a deadly weapon or dangerous instrument, a Class 3 felony that also occurred on November 17th, 2024. As to count 4, the drive-by shooting, probation is available. I could place you on probation for up to 7 years. As a condition of probation, I could order you held in Pima County Jail for up to 12 months. As to count 6, the aggravated assault, probation is not available. And the sentence to count 4 shall run consecutive to the sentence imposed by count 6. You're to have no contact with the victim. Alternatively, I could sentence you to prison to both counts. Count 6 again is mandatory prison, but as to the drive-by shooting, the prison sentence would be presumptive of 5 years, maximum 10 years, aggravated 12.5, minimum sentence 4 years, mitigated 3 years. And as to count 6, the aggravated assault, the presumptive sentence is 3.5 years, maximum 7, aggravated 8.75, minimum 2.5, mitigated 2. If sentenced to prison, you'd have to complete at least 85% before you'd be eligible for release, and upon release, you'd be subject to community supervision. Also, if I did place you on probation as to count 6 and you violate that probation, I could continue on probation, including a jail sentence, or revoke your probation and sentence you to prison for the length of time I just went over. And again, these 2 counts will run consecutive, meaning one after the other. Do you understand that's a possible sentence I can impose based on your plea of guilty?
Yes, Your Honor.
Are you currently on probation or parole in any jurisdiction for a felony or misdemeanor?
No, Your Honor.
The court does not inquire into your citizenship status, but if you're not a U.S. citizen, pleading guilty could cause you to be deported or removed or prevent you from gaining legal status for U.S. citizenship. If you're convicted of a felony, certain civil rights will be suspended. These include the right to vote, serve as a juror, hold public office, and possess a firearm. There may be other collateral consequences. Do you understand, Mr. Thomas, that once I accept your plea of guilty, you can't change your mind and ask to withdraw from the plea agreement unless you can show a manifest injustice? Do you understand that?
Yes, Your Honor.
When you plead guilty, you give certain constitutional rights. Among those, the right to trial by jury, that his verdict be unanimous and beyond a reasonable doubt. You give up the right to confront and cross-examine witnesses who testify against you, and the right to subpoena witnesses to appear on your own behalf. You give up the right to present other evidence or testify at the same time. If you chose not to testify, that could not be used against you. You give up the presumption that you're innocent until proven guilty beyond a reasonable doubt. You give up the right to have the jury determine aggravating factors unanimously and beyond a reasonable doubt before I give you an aggravated prison sentence. And you give up the right to file an appeal. Do you understand all those rights that you're waiving by pleading guilty?
Yes, Your Honor.
You do have the right to file a petition for post-conviction relief within 90 days of sentencing. So I'm going to ask for your plea as to each count. First, as to count 4, drive-by shooting, a Class 2 felony that occurred on or about November 17th, 2024 in violation of 13-1209. How do you plead, guilty or not guilty?
Guilty, Your Honor.
Next, as to count 6, aggravated assault with a deadly weapon or dangerous instrument, a Class 3 felony that occurred on about November 17th, 2024 in violation of 13-1204A2. How do you plead, guilty or not guilty?
Guilty, Your Honor.
As to both counts, are you pleading guilty voluntarily and on your own?
Yes.
All right, let me, Ms. James, you want to give me a factual basis?
Yes, Your Honor. On or about November 17th, 2024, here in Pima County, Mr. Thomas committed a drive-by shooting by intentionally discharging a firearm from a motor vehicle at an occupied structure. He fired multiple shots, and a person with the initials of CB was inside that structure, and therefore he also assaulted CB with a deadly weapon or dangerous instrument, which was a firearm.
Okay. Mr. Thomas, do you admit that's what you did?
Yes, Your Honor.
Is the state satisfied with the factual basis?
Yes, Judge.
Court finds there is a factual basis for the defendant's plea, incorporate the grand jury transcript, and find the defendant's plea is made knowingly, intelligently, and voluntarily. The court accepts Mr. Thomas's plea at this time. Because it's a prison-only plea, the court revokes release conditions and orders the defendant held no bond pending sentencing. The court orders a pre-sentence report or the defendant comply with the interview process, and will set this for sentencing. Will this be on the morning calendar or off the morning calendar?
I believe it should be on the morning.
Okay. All right.
I don't have any notes to suggest that that's not appropriate.
Okay. I'd like to go. I have a lot of sentencing. I've taken a lot of pleas today, so I have a lot of sentencing that week of June 9th. I'd like to go to the week of June 16th. He will get credit. So is that all right?
We can make that.
Okay. So let's go to Monday, June 16th. Does that work?
Yes.
Okay. So sentencing is set for Monday, June 16th. We'll be back in court on that day. Mr. Thomas, you do have to go in custody today, but you will get credit against your prison sentence for the time you spend in the Pima County Jail, okay?
And Your Honor, also, Emiliano had asked me permission just to speak to the court briefly. There's just
Sure.
something he wanted to say.
Yes, Your Honor. I would just like to say thank you for the time that was given out. It was a blessing in disguise, and I just wanted to be known that I'm grateful for that.
All right.
To you and the prosecutor.
Well, Mr. Thomas, I'm glad you showed up today. Sometimes people don't show up and we have to send the marshals out and they always find people, but I appreciate you showing up today and being grateful for the time out, okay? All right, with that, we're adjourned and you're excused. let's go on the record this morning in the matter of State of Arizona versus Lane Jeffrey Myers, CR 2025-1060, CR 2025-1454. These are both on the defendant's motion for a new hearing on release conditions. Parties' appearances. We'll start with the state.
Rachel Stiles for the state, and the victim is present.
Okay.
Lane Myers, victim.
All right. Mr. Myers is here on both cases, and then Mr. Resnick, your appearance.
And yeah, Judge Mark Resnick, sorry, as advisory counsel for Mr. Myers.
Okay. So we're here on Mr. Myers' motion to reexamine bail eligibility pursuant to 7.4.
Before we do that, I'm filing a Rule of 10. So
Okay.
The hearing has
Oh,
to.
that's the original. It's getting filed. Sorry.
Let's take a look at the rule. 10.1?
Yep.
Okay.
You got to transfer it and not have the hearing.
Hold on.
I can't let you do the hearing.
All right, Mr. Myers, I'm not going to let you represent yourself if you speak over me. I'm looking up the rule right now because this is new to me. You just filed it in open court, okay?
That's what I'm supposed to do.
Well, let me look at the rule, okay? I don't have it memorized.
I have to do it before the hearing is all I'm trying to say.
Okay, a party seeking, this I'm reading from 10.1B1. A party seeking a change of judge for cause must file a motion no later than 10 days after discovering the grounds exist, but may not file a motion after a hearing or trial begins. So you filed it after the hearing begins, so it does not apply to today's hearing.
I didn't file it before the hearing began. That was the point I was trying to make with these ladies over here, that it needed to be filed before the hearing began.
Okay, well, we weren't on the record, and I'm accepting it now that you filed it in
You're
court.
manipulating the rule.
I'm not manipulating the rule.
How can I file it from jail?
Well, Mr. Myers, you elected to represent yourself.
But I'm saying, how could I have filed it? How could I got it here any sooner than now? If I would have went home, I'm not home, but jail, and mailed it out on Wednesday, it would still be in the mail and it wouldn't be before the hearing. I made it clear to everybody in this room, the motion was being filed before the hearing, so that you didn't turn this into another kangaroo court like you do, where you manipulate the rules to your favor or the state's favor. The motion was filed. I handed it to them before you came out of the room.
Okay. It was filed in open court today.
No, it wasn't. It was filed before court.
All right. So I've addressed that, and you can take it up with the Court of Appeals if you think Mike
No,
Rule
I'm
is
taking it up
wrong.
with you right now.
No.
Take me back to the cell.
No. We're going to hear this hearing.
No, we're not.
Yes, we are.
Take me back to the cell.
All right. You waive your presence?
No, I'm not
Well,
participating in your kangaroo court. You're not going to manipulate the rules against me when the rule, I specifically filed it before the hearing. You're not going to pigeonhole me into this thing where you manipulate it was after the hearing started, so I'm denying it. No, there's no other way to get it here, and this is the way it was delivered, and I sat in the holding cell for since 6:30 in the morning, so it's not my fault if you can't get me a way to file it sooner. That's denial of due process in it itself. If I can't file a timely motion because I'm in jail, I'm being denied due process, and you're going to quit that.
So,
Just file it with the Court of Appeals.
Mr.
No,
Myers,
you're denying me.
because
Don't cut me off.
No,
you tell me not to cut you off. Don't cut me off.
All right, take him out of here. You're going downstairs. Let's go. You're misbehaving.
How am I misbehaving?
Come on, Mr. Myers.
You won't let me talk. Come on, you're leaving.
I'm not gonna.
Go on.
So my motion's filed.
You're misbehaving. I'm not going to talk to you
Then
again.
I'll take 5 minutes.
No,
Okay, so
You're
gonna
leaving.
Play games.
I'm not playing games.
You are playing games.
You won't let me speak, so you can't be in here.
I was speaking and you cut me off.
Let's go.
Come on.
You cut me off.
Grab your stuff. Let's go.
You don't need to grab my arm like that.
Let's go.
I can walk.
I'm aware.
Why are you squeezing my arm? I'm not squeezing your arm. I'm not taking a little walk. So is the motion filed for after the hearing or something?
All right. Since Mr. Myers was unable to control himself, I've excused him from the courtroom, and Mr. Resnick, you'll be his counsel for this. The only action I'm going to take today is I'm going to find that the motion to reexamine bail eligibility, I'm going to deny it without prejudice. He can refile it after the motion for change of judge has been heard, and Judge Liskey will address the 10.1 motion And then if he wants to refile this, he can. All right. Anything else?
Your Honor, and I would just note that the motion that he filed in court the last time, which was regarding this to re-examine the bail eligibility, it's not an agave, so I'm not sure it was actually put into the system.
Okay.
So-
Can we, we'll have to track that down.
Yeah, so I just want to make sure that that's in the court file.
I had a copy. I assume this is a copy that I have.
Judge, just, sorry, before we get too far down the road. Here's the problem. He represents himself and I'm only advisory counsel. If he's been removed from the courtroom, I don't know that there's anything we can do because I can't just come in and I can't just sub in and sub out like that.
Right.
He represents himself until such a time as the court finds that he's not able to. And I think it's State v. Bork. And the only reason I know that is because it was my case. There's a colloquy that the court has to go through with him, or findings the court has to make before depriving him of his right to represent himself. So I don't think we can do anything without him in the courtroom.
Okay. I'm only doing is making sure that there's a record. We have to track down the motion for exam to make sure it was filed. And I'm not going to hear that today, but he can re-urge that if he wants to redo that. So I'm not making any rulings today. Okay, so with that, Judge Liskey will take a look at the motion to strike me, and then we'll go from there. With that, we're adjourned and you're excused.